So thank you very much all.
Mabruk.
Today we will focus on the key issues for hoteliers to consider in their HMAs to avoid disputes in the future and any deflagging opportunities. So Hala, I'm going to start with you. Based on your experience in working with owners from inception to operation, what do you think are the critical issues to address when selecting an operator that typically, if overlooked, leads to potential disputes and termination in the future?
Sure. Just allow me before I kind of address this question, because this is quite a strict conversation. The title of this session is disputes, right? So it's kind of suggesting there's going to be a dispute. I just want to say and perhaps highlight that disputes are an exception, at least in my recent past experience over the last 20 years. It is an exception that you actually get to a dispute which leads to a termination or arbitration. Most of these contracts typically survive the 20-year term, and many do actually go for renewals, right? So just setting a more positive tone for this conversation that, you know, we don't go into these relationships to have a dispute. With that said, I personally am a bit more concerned, and that's how I'm going to answer your question, with the upcoming disputes, in the sense that it does seem to me the basis of how these agreements are being negotiated and formed in the current days are quite different than in the past, and therefore how to avoid the dispute, or what are usually at a very early stage the kind of issues that needs to be addressed sits within the panelists here, actually. Very frankly, I think legal, consultants, third-party operators, brands, and owners, they share an equal responsibility in how these agreements are being formed. And what we have seen typically lead to a dispute are those projects that the owner didn't really seek the proper advice from the point of view of legal advice, but more importantly from the asset positioning, operator's capability, and the why do we need an operator and what sort of operator. And I think also when it comes to the operators, are they responsible enough to advise the owner to actually what is true in terms of branding to the asset? And I don't want to kind of go further deep at this stage. I'm sure throughout the panel we'll discuss it, but there are real examples of disputes that couldn't have been avoided, but could have been avoided if the owner developed the asset the right way, if the brand was the right brand, and if the target segment was the right target segment.
I think that's absolutely correct, Hala. Shabel, maybe I can turn to you. From an operator's perspective, what do you think are the key issues to consider when selecting your partner to minimize any of those potential future disputes?
First, allow me to actually echo Hala point of view. Dispute are the exception typically. However, going back to the hotel operator selection stage, it's one of the vital stages. And I think there is so many criteria that everyone focuses on: brand suitability, the commercial terms, and so many other factors. However, one factor that has been overlooked and undermined was compatibility. And I think compatibility is one of the most essential factors that actually can allow in establishing long partnership as it avoid dispute in the future. What we should look at compatibility, two aspects: shared values and objective for the hotel itself, and the cultural fit and values. On shared objectives, it is important from the outset that the two parties actually agrees what they are expecting for that hotel. So in terms of returns, product positioning, and so many other factors. As long as the two parties actually are pushing in the same direction, results are great, returns are great, and as such, disputes will not arise. If the two parties actually, on the other hand, are pushing in the opposite direction, this is going to happen. So it's the property will suffer, profitability will go down, and eventually going to lead to dispute and even sometimes to debranding. In summary, I think we have all responsibility here to advise our owners to ensure that we select the right partners, and we should look beyond commercial commercial terms, brand, and these kind of things, and look at aspects like compatibility and how we can ensure there's a fit. And it goes even to actually beyond that. Sometimes it leads to selecting the operation model, whether a franchise or management agreement, and compatibility, I think, will help us in determining these factors in the future.
Yeah, agreed. So Hal, turning to you, you have lots of experience on the owner side for many years, signing lots of HMAs. Why is the hotel management agreement so critical for the owner, and what factors do you think have influenced their development?
Thank you, Keri. It's a very good question. Allow me to start from the second part of your question. How the agreement has been evolved or developed over the past year. If we see during the last couple of decades, the relationship between the owners and the operator has been evolved, let's say, big time. And I can say that it's due to two main reasons. The first one is the owner, the kind of owner has been changed from an individual asset owner to, let's say, an institutional asset owners. This lead to, let's say, the owner to be more educated, more exposed to let's say, to hospitality standard. And this was one of the main reasons why the relationship between the owner and the operator should be also at the same time evolve or developed. The second part also related to the market dynamic. The market has been also dramatically changed, especially in our region. When we say, for example, Saudi Arabia, usually before 20 years ago, you will find only one brand in each city. Now this is not the case. That makes the owners think really about their interest in their assets or in their hotels, and try to, let's say, maximize their profitability. Before, the competition in each city was very minimal compared to the current scenario. So that's why the owners now start looking at HMA very carefully. This is very important to maintain the relationship between the owner and the operator. Try to avoid any, let's say, dispute down the road. This is actually the main reason why HMA is too critical for the owner and for the operator also to be drafted and to be supervised very carefully.
Great, thank you. Jad, turning to you, I think you have a really interesting role. What do you think are the key differences between an independent hotel operator or third-party operator HMA and a brand owner HMA? And what do you think works particularly well for owners?
As Sohail said, the HMA is very important for both parties. I honestly believe it's more important for the brand owner than the owner himself or herself. Is protecting, if you read an HMA, I'm sure you did many, it's quite protective for the brand to start with, right? When it comes to third-party operator and the business model where we work for the owners, this is the model itself, right? And we don't have necessarily any loyalty for any specific brand, though approved by most of them. The HMA that we draft for the owner comes much more simple, right? Much more dynamic, adaptive to the owner's requirement. Of course, it has some similarity in the clauses with the brand owners, but it has much more flexibility, and most of the issues that have basically been arising between owner and operator are related to the involvement of the owners in decision making, which is something we're offering more than the brand owners. Eventually, not because they're not good or we're better, it's not that. It's the nature of and the size, the scale of the business we run is smaller than the brand owners. And it gives us the flexibility and the capacity to accommodate owners' specific requirement in this market.
That's certainly something to think about. Thank you. Charbel, if I can come back to you, I'd like to ask you, what do you think are the key considerations when designing a HMA to minimize those potential disputes in the future?
Well, I'm not a lawyer, but I'm going to try to answer that question from the design of the HMA. And I would like to address the topic more from a holistic point of view and strategic point of view rather than going clause by clause. And there's two criteria that we like to work on: the spirit of the HMA and actually the principles. if we get the spirit and the principle of the HMA, all the clauses becomes a derivative of it. If we agree on these, then we can sort out all clauses, which are important, and we have to do it. On the spirit of the HMA, I think the design of the HMA should take into consideration the long-term relationship between the operator and the owner. And as such, I don't see the HMA should be read as a transactional contract where actually we negotiate the HMA, we finish, we sign it, and then we just put it in the drawer, and then we just take the HMA when things go sour. So it should be looked as a live document, like a playbook between the owner and the operator that guide the relationship throughout the process, and it's important that we do that. You know, and on the second one, on principles, I think, and I would like to take this because, you know, at IEG we prioritize these kind of the long-term relationship, and we apply collaboration, transparency, and open dialogue. And these principles, actually, commitment allowed us to actually to retain owners and to keep great relationship. And I think if we take the same principle and we apply in designing an HMA, it will allow us actually to minimize dispute and avoid any deflagging in the future. So what kind of principle that we can talk? I think if we take 5 principles: transparency, flexibility, simplicity, clear definition of roles and responsibility, and actually encouragement of open dialogue. I think transparency, it is important that at the outset we set clear and honest expectation in drafting the HMA and designing the HMA, and as such, transparency will lead to trust, and trust will lead to a long-term relationship, and it avoids all kind of dispute. And flexibility is something as well very important that we don't give much importance, but flexibility of the HMA, if we design it in a way that will allow the operator and owners evolve the property through time to respond to the market. If we don't evolve, we're not competitive. If we're not competitive in the market and not responding to the new guest requirement, then the property will suffer. And that will lead actually to these kind of dispute. Simplicity, well, less is more. I think this is, we all agree, less is more. I think we've seen so many HMA that are so complex, so much jargon, and becomes so difficult that we don't understand, and it actually leaves so many misunderstandings. And misunderstanding is one of the key issues that actually put us in dispute. I think if we have an HMA that can be read by anyone in both companies, is the best and better HMA because everyone can understand it and follow it.
And I think I liked the reference to a live playbook. That's absolutely right. Hala,
Can I perhaps just add to what Sherbel is saying, having seen some of those, I wouldn't call disputes, but how important flexibility is, especially in evolving markets. I mean, clearly, in the past, we used to sign HMAs for 25 years. You know, perhaps now the average is 17, right? It's not 15, it's not necessarily 20, but whatever it is, it's just too long to not be flexible. And where we're seeing clients at this stage frustrated, if I can use the word frustrated, and I'm sure you can relate to that, having those discussions with owners, is that in reality, as an advisor as well, we're looking for the operator to optimize the value of the asset. So that's not just about booking channels, it's not just about the occupancy. It is about optimizing every square meter in this building. And where we're seeing now some of these discussions is not to suggest you're the base or the incentive fee. I mean, what you would have thought were typical in the past, right? I mean, owner's guarantees, the term. It's much more. Can I come in 2, 3 years or 10 years down the road to actually have a conversation with the operator that I'd like to rescope or repurpose a couple of floors into a different use? Can I carve out this space? Can I bring in a third-party restaurant operator? Can I do something differently? And is the operator willing to actually come to the table and say, you know what? Yes, my NPV suggested X, but I'm willing to do that in the spirit of actually preserving this relation. So far, we haven't, I wouldn't say across board, but these are the tougher conversations, because if I'm an operator and I have another 7 years, in fairness, I'm going to try to hold very strong to my remaining 7 years. In reality, the owner is looking at it from the point of view, I need to cover my commitments, my financial commitments. So I agree with you. Can we perhaps provision, because there is the manager's duty, there is the owner's duty, and I heard you talk earlier on about the owner, and you as well. And you know, this is where you basically, if the owner wants to be hands-on, in fairness, they shouldn't get the operator because they're going to make their life difficult, right? So it's also about that transparency. But I think flexibility is what we haven't seen yet. We've seen simpler contracts, but they're still very contractual, that sitting to the table and saying, you know what, you're not going to have 250 keys. Give me please 50 keys back because I'm going to transform that space. And that's where I would be keen to hear from you. How would you react to something like that, and whether you've experienced something like that, Sohail, as well?
So we need to optimize the asset, I think.
Absolutely.
Is what you're saying.
Yeah, essentially.
Yeah.
Yeah.
So Sohail, just kind of reflecting on optimizing the asset, what do you think are the issues that we would need to consider in a HMA to establish that long-term relationship with the operator to avoid those disputes in the future?
Okay. Let me first second what Sharbal has mentioned, that it's building a long relationship between the owner and the operator is very, very important. That's why we always tell our partner, the operator partners, that it's always about a win-win situation. It's not about how much I get from you, either the operator or the owner. That's why it's very important to, let's say, to have a clear, understandable HMA to avoid any, let's say, misunderstanding or any let's say, reading from a different view of point. This is very important. Sorry, and to avoid this, I think one of the main risk maybe the HMA will have is, let's say, have some ambiguity. Having not clear, let's say, HMA will lead to a dispute later on between the owner and the operator. Also, at the same time, alhamdulillah, lately the operators start understanding the owner concern, whether is it financial or, let's say, monitoring the performance, because from the owner, it's all about, I want to get the maximum out of my property. This is my only concern. I want to maintain the reputation of my property. And definitely, I engage the operator to maintain this, to get me the best out of this asset. So to reach to this, let's say, target, we need to work together. It's not about, let's say, it's not a competition. It's always about how we, let's say, work together, because it's a very long relationship. We always tell our partner that HMA, it's only about dispute, but the relationship, we should have always open communication between each other, so we both together we reach to our target.
So we need to avoid ambiguity. Maybe perhaps we can instruct
Definitely.
lawyers to help with that. Jad, do you think that third-party independent operators being entrusted by most of the hotel brands can bridge the relationship between the hoteliers and minimise contractual conflicts between them?
Absolutely, yes. Not only with regards to conflicts. In Europe and the States, the model of third-party operators predominating actually over the management agreement, which is the natural way of doing business with brands, right? In the Middle East has its reason for having a majority of HMAs versus franchise and third-party. It's mostly related to the experience. But yes, the role of the third-party is to bridge that relationship, and it's kind of a triple win, right? For the owner, for the operator, and for the brand owner. Because what owners want from a brand is mostly the brand awareness, the connectivity, and so on and so forth. But on the other hand, owners, and again, as Hala said, owners want to be involved. Why then would they get an operator? The fact is they want to be involved in decision-making more than really in the operation. And that's where the brand owner cannot often accommodate that. Again, because of their scale, they manage thousands of hotels. When we come in, we can accommodate that part, as I said, but we can also definitely protect the brand interest in that property. And that's why they entrust us and others, of course, not only us. So that's kind of solution. Since our HMEs are less sophisticated, no matter how simple they're gonna go at the brand agreement, it's gonna always be much more simple with third parties and much more adaptive to the owner's requirements, right? I mean, the example you give, an owner wants to come and take 50 rooms, convert them to apartments. For us, it's a 5 minute meeting to decide and change. For them, it's gonna be a long process that could drain the owner's, excitement about this. But it doesn't mean that they wouldn't do it. It's only that we can do it a little bit faster because it's us and the owner, and that's it. So yes, definitely we're a solution. We're not, and they don't see us as a competition whatsoever. Actually, it's complementing each other. And recently, they have been coming a lot to us to do that model because it helps them better with their relationship with the owners. Less hassle for them, more for us, but that's the nature of our industry.
Great. Just changing the focus slightly, Hala, maybe I can just ask your views on when you think that a HMA works better than a franchise agreement, and vice versa, when a franchise agreement may work better than a HMA.
Yeah, in a very simple way, it is driven by market cycle. And the reason I say that is because we've just given an example of Europe and the US. I think definitely from an ownership structure and much more from experience, I think there are enough experienced owners today because HMAs are pretty much straightforward. We're managing on your behalf. We have the expertise. You've invested. You want us to operate. But from an ownership structure, whether as we sit here in KSA or even in UAE, you have now large groups that have multiple assets, right? And we've seen, actually, in the last 5 years, a lot of those HMAs convert into franchise contracts. And that is quite realistic. I know the operators wouldn't typically mind it to give a franchise if they're franchising out to an experienced owner, or when players like Aleph come into play to actually give this additional comfort. But definitely, so we wouldn't typically recommend, so if I'm actually making a recommendation to owner with very minimal, if any, experience, let alone whether the brand will entertain or not, I wouldn't recommend franchise. I mean, it's oftentimes easier said than actually done, thinking that if you just have a brand up in front of, at the top of your door that you can operate, it is not easy, and hence why you have many years of experience. But as I said earlier on, there are owners that typically want to be much more involved than just invest. And they are the ones that it's not just about the type of the agreement, it is also who the operator. There are at times a preference for the smaller operator, at times preference for larger operators. Who is your target segment? So it is quite different considerations to form a recommendation. Franchise is typically recommended when there is enough of an infrastructure, because it's quite costly as well to hire an entire team, and I'm sure you can agree on that one, to actually, because what you're doing, you're asset managing, right? You're asset managing so many different assets under the franchise model. So we do consider that. I think from an operator, and I'll allow myself to speak for them, because the way they can actually grow into secondary markets, and that's where we're seeing also the opportunity of franchise, is in places in Africa, but more so even in secondary markets, let's say in KSA, where they don't necessarily have the know-how, but even if they have the know-how, they don't have the spread. And that is where it makes sense as well. So it's a lot of discussions with the owner, but I go back always to the key question or the key recommendation to owner. They need to align on the scale and the size of this asset and what is the operator going to bring to the table under either form of contracts.
Yeah, agreed.
Yeah, and we've seen actually to that effect, we've seen perhaps not so popular, but the franchise concept, right? Yeah. Where we're saying as an operator, we're helping you in the next 7 years. We're going to trust you, and then you can roll out
Flip
with
it.
your own, flip it
Yeah.
into,
Franchise, yeah. Jad, if I can just turn to you again. With the growth of the third-party independent operators in the region and better acceptance of the dual contracting by owners, how do you see this helping to maintain stability of the HMA and the franchise agreement?
Am I? Yeah.
Yes.
Yeah. The model itself, of course, started slow, is picking up a lot with us and other players coming to the market, and hotel owners are appreciating that fact, and yes, they want a brand, fantastic. They can get the brand according to their first desire, but also their eligibility for that brand. And then they get the operator they want who will protect their interests. And then that also avoid other conflicts for both parties. So for instance, again, I go back to where we can always accommodate better than the brand. They want exclusivity or protection area. We can offer that based on our own tourists. It's very hard for big brands to offer that when it comes to the number of brands they own and the hotel they want to manage. So yes, we do have, and that's just an example, there are many other examples where we can come in and first maintain that relationship. So if, for instance, since Shaib is on IG, a Holiday Inn is signed and we're managing, if they operate another Holiday Inn, it's our challenge, not the brand challenge, because they have no obligation. But also we definitely know how to attend to this by avoiding internal competition between two managed Holiday Inn. And the owner can get some comfort in that case that, okay, they're not gonna steal my business, there's somebody else protecting my interest. So that's just an example. There are many others, but yes, it is definitely helping the stability of both the agreement, the franchise, and our own.
Thanks, Jad. So now we're going to talk about when things go wrong. We've signed the HMA, everyone has put the contract in the drawer and is kind of getting on with their lives. But we have a dispute and things are going in the wrong direction. There are a number of factors that the parties will need to think about, costs associated with potential termination and rebrand, governing law, whether the dispute will be in the courts or arbitration. So Hala, when a client comes to you and asks for your advice as to what to do next, what would you recommend?
I mean, so typically we definitely don't recommend a deflag or a rebrand at the first instance. I mean, there are those rare occasions when it was clear and obvious, but oftentimes there are so many, and that's typically what we call our assessment as an independent party, and really trying to understand and help this discussion between owner and operator. There are some valid points that are usually made on either end of the table. I mean, clearly it does assume that both parties are interested to continue this conversation, but I'm again going by the cases we have seen, is that typically our recommendation is really to try to understand what is the issue and how it can be resolved. 80% of the time it has been resolved, perhaps not as best as it could, but when you run the numbers, because again, I come from a background where unless the numbers do suggest that you're going to be better off, then I'm not necessarily, unless it's not an emotional decision, if you know what I mean. There is a decision that will be founded by the fact, if it's an underperformance, can someone else perform? And I just can share at a very high level without disclosing the asset, a classic example of an owner 4 years in a row that wanted to deflag, thinking that bringing in another operator is going to technically generate a much higher return. If we look at this asset was meant to be a 4-star, finished at almost a 6-star, although I don't believe in 6-star, but that's how luxurious it is. And it does sit in a 3-star location. Now, we recommended against deflagging, but they still went ahead and deflagged and brought in another operator. 2 years down the road, the same issue, because the issue wasn't resolved, right? So it is sometimes an owner overspend and not necessarily an operator, and at times it is an operator issue related, right? So either this operator is going back to this flexibility, either the operator actually acknowledges that yes, we can do more and we ought to be doing more. So that is our approach, is really to understand and make both parties understand. And oftentimes we're successful because we're quite independent and not conflicted. At times when it does actually result in, you know what, pretty much we have to part ways, then it doesn't also have to be ugly. We've seen example when it was done in the spirit of actually enough respect. We've tried so many times and it's failing. And times where you can say more than me, that it has gone actually to arbitration and it turned ugly and sour. But my advice is you need to start at the right place. You don't end up in the wrong place, right? There's a lot of work that needs to be done, and I insist again on the decision to enter into an agreement. What was it based on? And that's why I said earlier on, my concern moving forward is that we're going to see much more disputes, because some of those contracts are not based on what the market opportunity is. What is the strength of the brand? Some of these opportunities are based on we need to develop, and we need to develop fast, and these are the brands that are available, and let's just push forward, right?
Yeah. I agree with you, Hala. I mean, I would always advise against going to court and arbitration, because there's only ever one winner, and that's the lawyers. But maybe perhaps, Sohail, if I can turn to you, if you find yourself in a position when you're extremely dissatisfied with an operator, what would be your next steps?
Well, it's a very difficult question, and maybe operator they don't like.
And you have experience on that one.
First, allow me to echo what Hala has mentioned here. I think, let's say, dispute, both owners and operator, definitely they would like to avoid this, because it has many risk related to it, and we try to avoid it. For example, we have signed an HMA. For example, in Royal Madinah, we already signed with Marriott 8 brands, with Hyatt 3 brands, and today we already announced a new signing. Unfortunately, I missed that ceremony. We do this to build a very good relationship, to let's say uplifting our assets, to also to reach to the maximum benefit for both of us. But however, if we forced to do, let's say, if there is a conflict or dispute between the owner and the operator, there are several steps needed to be done from both sides. I think the first thing needed to be done is, let's say, assessing the situation. What is really the issue here? We need to understand it. We need to fully review what caused this issue and try to, let's say, find a solution for it. After that, I think we need to review or refer to the HMA to know exactly what does the HMA says about this issue between the owner and the operator. After that, I think it's good to communicate with the operator, because communication is the best solution for any issue between both parties. This is need to be open-hearted, need to understand each other, so try to reach a resolution. After that, if let's say the issue is still there, we need to, let's say, revoke the dispute mechanism. Maybe an arbitration needed to be reviewed or to be done. And still, if there is an issue, I think the next step is to review the HMA and know exactly what is the other option available for the owner. And at this stage, I always say, and I have to repeat it 3 times here, always seek a good legal advice. Always seek a good advice. Always seek a good legal advice, because this is actually the main input you need down the road.
That would be my advice as well.
And if khalas, you decide to go to and proceed with let's say with any option, if one of them are the termination, then you need to prepare your takeover plan to maintain your property and to make sure there is no disruption in the operation of that hotel.
Yeah, and I think that's a key point, to ensure that the operation continues without any disruptions. Charbel, from an operator's perspective, when things start to go sour, what do you do next?
think they pretty much said it. It's communicate, communicate, communicate. I mean, from experience, I think most of these disputes arises from misalignment or misunderstanding, and something was missing. So I think the first thing, I don't think it should happen. It should not lead there if you have an open dialogue, going back to these principles that we spoke about. So as long as you have always an open dialogue and communicating always, you're not going to reach there. But if you reach there, I think you have to act fast as an operator, attend to the owner, understand what his requirement, why are the issues, why he has these issues, and have an honest discussion and, you know, and communication with these, and then attend for a solution. Hala gave the 80%, I would say 99% of any issue has a solution. It might be sometimes difficult solution or easy solution, but it has solution. And I think you're going to like this. When we attend to these discussion and communication, we need to have the intent and good faith in sorting out the problem. If we have the intent and a good faith, we always sort out the problem. In summary, when there's a will, there's a way.
Yes, agreed. Where there's a will, there's a way. Jad, turning to you, do you think that a third-party operator can act as a mediator in these circumstances, and can you bring that as a bit of a value add?
Sorry, can...
So do you think that you can be brought in, or you can assist when there is a dispute and act as a mediator to bring together?
Well, legally, no. While there is a management agreement in place, we do not get involved even as an advisor or any, like, we're an operator after all, so we don't compete, and that's definitely not something we want to get into. After all, our relationship is balanced between the brand owners and the owners themselves. We're here to serve both purposes, right? If the owner doesn't want a brand, of course, we're directly involved with them. But when there's a brand, there's absolutely no involvement until the owner and the brand have agreed on that.
Yeah. Great. Thank you.
Thank you.
We have 7 minutes left, so we're going to open the floor to the audience if they have any questions for the panellists.
Well, we've been very clear, obviously.
Please go
So-
upstairs.
Do you have a question? No, we haven't.
This gentleman.
Listening to you guys in terms of management agreements and what the dispute possibilities are, do you think it gets, I think I want to point this question to Hala and Sohail. Getting a third-party operator in the equation when you know you already have a sensitive agreement in place, do you think that makes a lot of sense when you have three bodies involved? Dispute, I mean, you're talking about third party, the main operator as a franchise, and the owner. So does that make logical sense to have all three bodies involved in terms of any sort of dispute?
I don't think that's what I understood, at least from Jad, but my view is you can get a third-party operator while you're at a dispute, right? No, it's not going to resolve the problem.
No, my question is that, does it make sense to get a third-party operator?
Well, you
without
could
the
get,
dispute part, because IHG,
okay, yeah. So that's more bringing in a third-party operator with the brand.
right. Now you're an owner, you already have an agreement, then you need a third party from from an intellectual standpoint or whatever, but you want to have another professional organization involved. Does that make sense for you as an owner?
Well, it depends from an owner to another. For some owners, actually, it's a very good option to let's say, to deal with the third-party operator, because there are some benefits also you can get it from a third party, especially in certain location. The third-party operator can act on your behalf. If you are an owner who does not have any, let's say, background or hospitality knowledge, this is a very good option that you engage a third-party operator who understand the operator requirement, who understand how the the operators deal with the operational activities. So in some for certain owners, yes, it's a very good option for them. For other owners, they prefer to deal directly with the operator. They do have, for example, a very good hospitality team who can manage the day-to-day activity of the operation. So it depends from one owner to another.
So just before we close, I'm just going to ask each panellist to give just one takeaway from today to avoid disputes in one sentence. Perhaps we can start with you, Shobham.
Ensure to get the right partner, compatibility.
For me, I believe in open communication, because I believe open communication always can solve issue or dispute between both parties.
I cannot say the same, right? I have to come up with something different.
You can pretend dead.
Yeah, right? No, I definitely believe in communication, but I think, again, I am stressing a lot the fact that it's extremely important there is alignment. You know, when an operator comes forward with projections at the very start, right, when you're shortlisting operators that are not mirroring the potential, so they're either too aggressive or too conservative, you need to ask the why. So sometimes, often, we're too excited, right? So we just really need to understand from the very early on what's at stake. When it turns sour, it turns sour. But I think these relationships have worked, right? So they can work. It just requires that openness.
It's a goodwill. It's a goodwill between for both parties and less sophisticated thinking. After all, it's a piece of paper, and if there's a conflict, they can drag it for years, and nobody's gonna have a good night's sleep, you know. So goodwill, and then everything is solved.
If I may add, also, in addition to the open communication, we really need to understand each other's concern. The operator need to understand the owner objective, targets, and also at the same time, the owner need to understand the operator standard, also at the same time target. So understanding each other target is very important also to build a very good relationship between both parties.
Can I make a recommendation? And I think this may solve disputes, right? But again, from what I've observed, oftentimes when you're signing the HMA, you're definitely dealing with the development team. And past that stage, it's the operating team, right? The operations. And that alignment as well is extremely important. At times, I have thought how important it is to actually bring on your operations team at the time of signing. Because in reality, as an owner, once it's up and running, you're dealing with a very different team. So I don't know, I mean, if that's something that you feel potentially could be.
Actually, thank you for this. Actually, this is something for the past year. We've been doing it. Our VP Operations Saudi is present on most of our deals now with the owners, and we sit down, we discuss, and even when we're doing actually with our partners and the third-party operator, we bring them along, and we are discussing these issues because we notice there's a gap between signing an operation of 3 years where you have the development and suddenly a new team comes up, and I think continuity is very important. And actually, thank you, Hala, but
Super.
we're on it.
Well done, you're ahead. Excellent.
Thank you very much, all. Please join me in thanking the panellists for the excellent discussion today.
Thank you, Keri.